Inge Graef, Björn Lundqvist, Martina Eckardt. Very warm welcome to Digital Markets Research Hub. We will be discussing today a topic which is very relevant to the bubble dealing with digital markets and competition policy, EU and beyond. But because so much is going on in everybody's area and European Union is so active in introducing new sectoral regulations in digital markets, we somehow try to be focused on one or two areas, but we are privileged to have some peers who are equally fluent in understanding the nature, the mechanics of competition and digital markets, and also looking at other sectors. And today we'll be looking at Data Act. So Data Act and Digital Markets Act are in some sense interrelated, but obviously they have different agendas and different mechanisms, etc. So we'll try to unravel this labyrinth with your help. And I propose maybe, Inge, we can start with you. Maybe you can explain to us what's the main objectives of the Data Act and what's the purpose of it?
Yeah, thank you for having me. So the Data Act is in a way quite a broad and also complex instrument because it has different parts. I think probably the part that is most discussed is the data access right that is created for Internet of Things devices. So where both individuals and businesses now under the Data Act have a right to ask access to data that is generated by a device, so that manufacturers of devices no longer have exclusive control over what happens with the data that is generated by their devices. So this should, for instance, also promote more competition and innovation in aftermarket, so for repair services or for complementary services. But then the Data Act also has other parts, for instance, on cloud switching, where there is a right created for businesses to move more easily between cloud providers. And another very important part of the Data Act is that it creates like a horizontal regime for data sharing. So there's many areas in EU law that either already have or will have in the future tools for data access. And the Data Act tries to set up some horizontal conditions under which that data sharing can happen. So in that sense, it also creates some level of harmonization across these instruments. So this is how I would summarize in a very broad fashion what the Data Act tries to do.
Many thanks, Inge. Björn, how would you do this?
I agree with Inge. It's a very good summary. If you would step away a bit, and I think the Data Act is very innovative in that sense. It tries to create a new legal system for Internet of Things, which is something we don't really know what Internet of Things is yet. So it's quite an effort from the EU and the Commission, and quite boldly to try to regulate something we don't really know what. And we don't really know how a smart city or a smart house will work. So I think it's quite elegant tool, and I hope it will work for the future. It does create a lot of questions about how the interfaces between the producer's right to collect data, which is the baseline of the act, even though not stating that. I mean, they do provide the idea that if the producer has the right to collect the data, while you get a limited right as a user to also then obtain some of the data, and that's. So the interesting thing about the Data Act is sometimes actually what it doesn't regulate. What does it indirectly regulate, I would say. But then it's also, as Inge said, it's a little bit of a piecemeal. It provides these rules. Then there's a lot about cloud regulations, which is something that I think the Commission put in there because they were dissatisfied with how self-regulation of cloud services was developing, and there's been some regulation which has not been so successful, and they wanted to do something about that. So it's both a new legal system, but also they pick and choose a little bit what should be inside it.
there will be a question about cloud. Obviously, in DMA bubble, we noticed that no cloud service has been designated as corporate as gatekeeper, but that maybe we could discuss it later. But I think some of viewers would be kind of surprised to learn that you break some stereotypes, that being a professor of competition law in Stockholm, you say that we are not yet it's not very clear for us what Internet of Things is and how to address it. So that's quite reassuring. So we are at the beginning of the journey still in 2024 in many respects.
Yes, I think so. I get many calls from producers or research institutions or whatever you have it, to say, what was going to happen now if we buy a research tool from Bosch or some other company, and they actually collect data? Do they collect our research data when we use it in the research institutions, or if we produce a truck? Yeah, and we buy some parts from, for example, the battery from a Chinese producer. And should they then collect all the data from our truck when it's driving around Europe? Is that the idea or not? I mean, it creates a lot of those practical ideas, which is I think it's difficult, at least for me to answer. Maybe you know, the other person on this call knows these questions better than I do. But it creates practical issues. Another big practical issue is that how much does this require all these producers to create large data centers? Do they need to, you know, store all this data for everyone to access it? That's quite expensive. Is that an underlying requirement in the Data Act? I mean, so it creates a lot of questions.
Thank you very much, Björn. Martina, let me ask you maybe to offer your explanation to normal mortal people what Data Act is and how do we address it?
Well, I think you already summarized it really good, and I'm an economist, I must admit, so I will only focus on the first part of the Data Act, which I think is very important from an innovation point of view. Also, the Data Act does not go so far as to really open up the IoT manufacturers' technical control of the data the IoT devices generate, but now it's the first time that there's a regulation where we have a first step that users get access to these data and can then distribute these data to third parties, however. And so I think that's a very important point, because from an economic point of view, digital data are so-called public goods. So they are non-rivalrous in consumption. And so from an economic point of view, there should be something like more open access to such data. Personal data protection notwithstanding, yes. But I think so far the IoT manufacturers could technologically exclude others from using this data, and nobody had the right to say, well, I want to have access to the data of the device I as a consumer own. So because with our personal computers, whatever data we create there, we own the content. So it's not clear why this should be not the case with IoT devices. So, and I think that's a very important point. I'm skeptical that the regulation goes far enough in really creating liquid, fair and efficient data markets for data intermediaries, perhaps. But I think we can discuss this in the following. Thanks.
Thank you, Martina. So let us try discussing these issues. And maybe, Inge, you can explain to us the main legal mechanisms underpinning the Act.
Yeah, so maybe going back to the IoT data access right. So there is a right created for users. So that means individuals and businesses. And I think this is already legally interesting, because I think it's the first act where I've seen the term users referring to both individuals as well as businesses. So this deviates, for instance, from data protection regulation, where it's always rights created for individuals, for data subjects. So under the Data Act, businesses and individuals are to some extent treated in the same way. So both individuals and business users have a right to get access to their data and to transfer that to a third party. So that is seen as a tool to indeed create more innovation and more competition so that you have more control over your data. And you can also refer it to whoever you like to work with. So you're, for instance, no longer stuck with a repair service of the manufacturer of your device. So you can also take that to a third party. And this is seen as indeed a tool to get more entry into these aftermarkets and also to give users more control over their data, since they are the ones who now under the Data Act can control where their data goes, and they can also choose for other providers of services next to the manufacturer. But legally speaking, there's also some how shall I put it, interesting choices made in how this IoT data access right is designed, where one can also argue or question whether the Data Act will achieve this objective of creating competition and innovation as much as possible. So this, for instance, is about the non-compete clause that the Data Act has, so where you cannot take data to a manufacturer that then creates a competing product. This is seen as a way to protect the investments in IoT devices itself, where I would question whether that is indeed necessary. I think we see in the market that there is enough investments in these kind of devices. So maybe this non-compete clause is not necessary for economic purposes, but it puts some restrictions to this data access right, which also can create, I can imagine, a lot of legal questions on when exactly a product is competing with the original one. So I could expect that this gives rise to some uncertainty and to some litigation. Just to give one example of where, you see that the objective of creating an IoT data access right is indeed what the Data Act tries to do, but where some choices in the design will still have to show whether it indeed reaches that objective or how far it is able to reach that objective.
Thank you very much, Inge. Björn.
Yeah, I can add to that. I think what may lead to a lot of litigation is also this exemption, which was put in there quite late in the legislative procedure, where this, I don't remember the exact wording of it, but very valuable trade secrets then the producers do not need to actually transfer that kind of data. I think that's almost a new form of intellectual property rights, which we haven't seen before. It's very questionable what kind of trade secret that would be that is so specifically valuable that you don't need to actually transfer it, even though you actually have, as Inge said, a non-compete clause added to that. So it's I think generally speaking, that users' right to data is quite limited in the Data Act. It could have been broader.
As a follow-on question, Björn, very quickly, I remember times when we were doing PhD in same place decades ago, and you've been at that time already preoccupied with relationship between competition and IP. So you mentioned sui generis IP right. Is it somehow linked to database rights and to all these kind of conundrums related to database right?
Yeah, not entirely. I mean, the interesting thing about the Data Act is that they do write off the database right in Article 41 or something like that. And that's, I think, constitutional-wise very interesting, because, I mean, if you're given a right to someone, that's a constitutional right that you have. While the Data Act now says, yes, you have that right, but you're not allowed to use it inside the legal system that we're now created in the Data Act. And that, from a constitutional point of view, I would question that a bit. Let's say that. Yeah, I mean, you have a property right, and it's a constitutional protection, and the Charter protects property rights as well as regular property. So it's I think the Commission and the EU has tried to steer clear from because they don't really want that database right to mess up the new system of user right data. But we will see how that will work. I don't want to deviate from what the previous speakers have said about this, but I'm a little bit hesitant to say that the Data Act actually gave users a right to data. So if I would take an analogy, let's say I would buy a house and I have apple trees on my house, and I buy this house, this real estate property. Yeah? I don't think in any legal system in Europe, the seller of that house could return a year later and say, well, about the apples, could you please give me the apples? And I said, well, I grew that tree. I mean, it's been in my care and I water it, and the apples are mine. I bought that property. You cannot come and ask for the apples. However, when we talk about Internet of Things now, the Data Act actually stipulates that if I buy a car, and that car creates data from my use of it, even though I own it, indirectly the Data Act says I have to give it to the car producer. I'm not so sure that that was the case before the Data Act. I think there are, if I would really drill into that, I think there have been cases, especially in arbitration, which are confidentially, unfortunately, that where actually, for example, ship owners have been able to get access, an exclusive access to the data that those small sensors, which was put in the large ships, for example. However, the question is whether that possibility now has been eliminated with the data.
That's really interesting trajectory of the discussion. Let us pause here and leave the curious minds to continue thinking about it, and maybe we will organize a separate meeting to discuss this purely juristic constitutional aspects of date of IP and property as such, etc. But maybe we can revert to you, Martina. How do you perceive the main mechanism, maybe some instruments, some elements of Data Act which appear to be particularly innovative or particularly problematic? How well written it is, and how optimistic you are in general?
Yeah, well, as I already stated, I think the big point, innovative point, is that it's the first time that now users have a legal right to perhaps get access to their data, because before they hadn't that right to ask the manufacturers. They could ask, but they had no right to get access to their data. As already mentioned, there are a lot of hurdles and barriers included, which still protect the manufacturers' more or less exclusive control over the data that devices generate. And I think there also might be additional, contractual strategies by the manufacturers, some buyout clauses, so that they say, user, please give me the right to exclusively use these data like before, and otherwise I don't sell the IT device to you. That might be also the case. And I think behind all of this is, there are conflicting interests, which we see now in the Data Act manifesting, yes, between, on the one hand, manufacturers lobbying for their interests to further have more or less exclusive control over the data, and other more promoting access to data because of competition or innovation or consumer empowerment interests. So, and I think we find both now in the Data Act, and that's why I'm very skeptical that all of these objectives will be fulfilled. And I think very important, let me turn back to one point. This is the question of whether there should be enough incentives for IoT manufacturers to generate or invest in further generating IoT devices. So from an economic point of view, there's a question, is the market fair? Can they recover their costs? Yes, because in IP, intellectual property rights, we have the idea that with innovation there is the question of positive externalities where there is a market fair. So we grant patents or copyright so that companies can recover the costs after the innovation has taken place. And the difference now is with IoT devices, manufacturers can recover the cost because they sell their IoT devices and they can recover the cost of investing in these devices due to the price they require from consumers. So there's no additional market fair which would require additional IP like rights for the manufacturers from an economic point of view. So
thank you. Thanks a lot, Martina. Inge, I leave you. I welcome you to comments on the issues raised by Martina and Björn, but maybe in conjunction with the next question or the next round, namely, when observing the discussions on the DMA, it was maybe our creative minds have structured it as a kind of as a battle between several stakeholders. Many lobbying strategies. So it was kind of, from dramaturgy perspective, very visually appealing, so to say. Can you somehow transpose this matrix to the Data Act? Can we explain, can we maybe try to unravel who are the main stakeholders, how active, how prudent their strategies were trying to shape the wording? Because sometimes we understand that commas even matter in these legislative proceedings.
Yeah, sure. What I know about the Data Act discussions is that in particular the manufacturing industry was very heavily involved in the lobbying. And I think like a big difference between the Data Act and the DMA is that the DMA, of course, covers, well, it imposes obligations on gatekeepers. Of course, the group of stakeholders is bigger than that. But the Data Act applies, across the economy, also to the smaller players. And I think that is a very important difference to keep in mind, that I haven't seen so much the smaller players who are also affected by the Data Act being involved in the discussions. So this is a very important difference, where the Data Act also applies to these smaller players who might not have the same resources to comply, and who were not so well represented, I would say, in the discussions. And then maybe another difference with the DMA is that in the Data Act, there were also some member states that were very active. So there is the Scandinavian countries, for instance, Estonia, who are very well advanced in using data. And then, for instance, in the cloud switching issue, which is one other part of the Data Act, separate from the IoT data access rights, there was also countries whose competition authorities have already done studies into this sector. So like France, the Netherlands, who had more clear ideas or thoughts on how that right should be shaped. So because the Data Act is quite a complex and a piecemeal instrument, you could see different stakeholders involved in different areas. And what I think like still a very interesting aspect of the Data Act is that we haven't discussed yet is the exclusion of gatekeepers in the DMA. So there's a very interesting link between the DMA and the Data Act, where the gatekeepers designated as such under the Digital Markets Act cannot benefit from the data access under the IoT data access right of the Data Act. So in other words, users cannot bring their data obtained under the Data Act to these gatekeepers. So the idea, of course, is that these the gatekeepers already have like a lot of control over data, and we don't want the Data Act to even make that pool of data bigger for the gatekeepers. But this is quite an interesting choice, because in a way you also limit the autonomy of the users. So you no longer have a choice to bring the data that you could get under the Data Act to these gatekeepers for a higher public goal. And I think for this aspect, there was, of course, also a lot of lobbying by the gatekeepers. But in the end, this exclusion is still retained in the final text. Also, I think because no one really dared to still change it, because you can imagine, yeah, if you're in the parliament or the council, you also don't want to be seen as the one who follows the lobbying efforts by the gatekeepers. So I think that's also a very interesting aspect in the discussions, that there is like a real, yeah, exclusion. I think the first time that I've seen anything like this in a legislative act, where the EU legislator made a clear choice for not allowing to let more data go to these gatekeepers. But this is very limited. So all other instruments like the GDPR, there's also a right to data portability, for instance, which is not affected. So it's quite a small exclusion, but I think it does give like a clear signal of the EU legislator.
Can I just, for clarifying this very potentially elegant and ambitious instrument with somehow using DMA designated, who you will, as a user, you will not be allowed to, or the gatekeeper, designated gatekeepers will not be allowed to access data, but only designated core platform services, other parts of gatekeepers, companies would be able to use it, or it's like it covers your entire corporate entity?
I would have to check the text to be sure. But the way I remember now, I don't have the text in front of me, is that indeed, if you are a gatekeeper, you're not allowed to get any of the data that a user could bring to you under the Data Act, and you're also not allowed to solicit users to do that. Mm-hmm. But maybe
yeah.
my fellow panelists know for sure.
Thank you very much, Inge. Björn, how would you explain this to us?
No, I agree with Inge. I think that she remember right, if I understand it. But still, we can create oddities. I think especially if you buy a product which is where there's an operating system included, and you using an operating like Google Drive, for example, if you want to have it in your car, and some car producers use Google as their system inside the car, and then I would guess, technically speaking, that system needs to access a lot of those parts of the car. So there may be possibilities for gatekeepers to circumvent this prohibition, I would say. But I'm not an engineer, so I'm guessing a bit there.
I just checked. I just checked the wording of Article 5. Yeah, I think of Data Act. So Article 5.3, any undertaking designated as a gatekeeper. So it covers, as you suggested, Inge and you, Björn, because otherwise it would make probably a little sense, because you can. Okay, please. So go on, please.
The same thing also, if we talk about cloud services, that mirrors a lot of the gatekeepers, honestly. So yeah, because that is not, it's not, so they don't have a right under the data access right, but as a cloud provider, they might be able to access a lot of that data too. Yeah.
So they might, the thing.
But now then we need to start reading further in the Data Act. We need to come up there to Article 23 and continuing. Then it's the cloud services, and yeah, it depends a little bit. I mean, you need to possibly, for all this data to be accessible, and also to be that you can number crunch it. It needs to be in a cloud somewhere. So one thing I think which is we haven't heard about in quite some time is this idea about data sovereignty for Europe. I'm not so sure that we still, or the politicians in the Brussels are still pursuing the idea that we should have a European cloud service provider. It seems that we have, they have backed down from that political policy goal, and we're only going to have the clouds that are still available to us. But there's an interoperability clause or article in the which is quite interesting, that you are able to actually to have two clouds at the same time, so to say, like two cloud service providers. That might open up for European cloud providers in niche products, I would say, not as a general cloud provider. Otherwise, what came to mind when Inge was talking is that, which I think is quite interesting too, from a private law perspective. We have no private lawyers here on the or law researchers on the call, but it's those articles, Article 3 to 13, which deals with data access rules, are really about private law. It implicitly implying what should be in the contract between users and producers. And that is quite unique. I mean, it's a new step for the EU to step into private law, contract law, stipulating hard rules about what should be in your contract, which you cannot really step away from.
Can you just explain to us that private law is not, or there is only attempts of EU to cover private, yeah?
True, yes. And this is really a step in that direction, which we haven't really seen before. And also that from a competitional perspective, I think this Article 13 about business to business, I would say fairness regulations, something like that. That is also, it's a very broad clause, at least from a Nordic law perspective, which we haven't had before. We haven't had those fairness rules when it comes to, it's more unfair competition, I would say, from a German perspective. I think for competition lawyers, that could be an interesting analysis to do. How far can we use Article 13, both from a fairness perspective, but also from a competition law perspective or competition policy perspective?
We have in the UK this new act, Digital Markets, Competition and Consumers, still bill, but act, and their links between fairness and competition will be even more accentuated and I think turbulent. It's still somehow not addressed, but I'm sure we will have opportunities to look because they somehow in one article, they refer to both very different objectives with very different pedigrees, but that's a different conversation. Thank you, Björn. Martina, and your views on this kind of stakes and stakeholders, how the discussion was shaped.
Yeah, well, I think that, as we already talked about, there are contradictory narratives. On the one side, the manufacturers, on the other, the consumer protection aspects. But what I also find very interesting is that not in the proposal of the DA, but in the final version, then there's a clarification in the recitals that data that users can request their data, give them to third parties, which then can commercialize these data and give them to data intermediaries and other companies then. And I think that's very interesting because, as far as I know, that following from the Data Governance Act, where we have these data intermediaries, so far there are not that many data intermediaries at work currently, so there are no stakeholders lobby organizations there. I don't know who, I think it's the EU position, had been the EU position then to bring this into the final version of the DA, that to clarify that users can really sell their data to third parties and that they can monetize it. And I think that's very interesting. So, but perhaps you know more on that. I don't have information about this.
Many thanks, Martina. Inge, let me ask you, maybe with this, when we were discussing the DMA, there was not very well articulated, but there was voice of this emerging industry of data brokerage who were trying to either to represent consumers or somehow collect on industrial scale data. What do you think about these opportunities for as a business model for companies, or I don't know, maybe some NGOs or maybe some quasi-sovereign funds to try to accumulate data which are being harvested so have been generated so generously, and when there is a kind of an attempt to unbreak this bubble, will they emerge? What would be their role? Do they have prudent business model? Is it completely unknown territory for us?
Yeah, so I would link this indeed or also to the Data Governance Act, like Martina already did. And I think in this sense, the two instruments could be aligned. So you, under the Data Governance Act, the EU legislator created a regime for data intermediaries. So these are indeed like platforms that stand in between data holders and data users. So you can use these mechanisms yourself as an individual to manage your data, for instance, get more control, but also like share your data with other third parties so that you can use more services than before. But it can also be used in a business-to-business context. Where businesses can also make use of their data more effectively. And so this is a regime that is created by the Data Governance Act. And in a way, you can argue that the Data Act creates, by this data access rights, a way for these data intermediaries to be more effective, because indeed you now have a right to have access to your data. So with the data intermediaries under the Data Governance Act and this IoT data access right under the Data Act, maybe we will indeed be seeing more of these services. But I think you already referred to business models. I think this is a key question, like how will these services scale up? Because we also know under the Data Governance Act that they are subject to quite strict regulation. So for instance, they have to be completely neutral. So this means that they cannot commercialize the data. They can only transfer the data between the user and the holder. So they can't create complementary services with the data that they exchange. So this has to be completely separate. And this is, of course, stems from a concern that we see, for instance, in the big tech industry, where a lot of these players are vertically integrated and they get a lot of control over the data and also use that in a very commercial manner. So how I read this is that the EU now tries to set up data intermediaries, but fulfilling the European values. So not going for this typical business model of commercializing data, but making sure that they comply with like the European values and the rights that we have, so that that they cannot exploit the data as we see this, for instance, now happening in like advertising-based models. But then, of course, you can ask the question, how do these services then get funded if they can't commercialize the data? So this is a big question where I indeed also wonder if we will see these data intermediaries emerging. Because we also know that although people say they care about their privacy, if they have to pay for this, and indeed a subscription model, I think, would be an alternative business model, they might still not be ready to do that simply because they're used to these services being offered like for free. So this is a big question that I have indeed. If people are willing to pay for these services, and maybe this happens more in the B2B context with smaller businesses that might be willing to pay for managing their data, that then we might see more of these data intermediaries that, together with the Data Governance Act and the Data Act now get, at least I would say, more perspective to grow. But a business model, I think indeed that still needs to emerge.
Thank you very much, Inge. I just noticed, by the way, auditing the compliance workshops, DMA compliance workshop earlier or in late March, that one of the gatekeepers said that while designing compliance strategies with their obligations, they will try to, when the business users will be assigning their rights to collect data for third parties, they will try to avoid this commercial brokerage relationship because it will be a threat to security. So they see it as potential challenge to their business model, not using security as pretext, or maybe the challenge is really security as we see with third party cookie stuff, as you mentioned. Björn, what is your reading?
Yeah, I agree with Inge. The business model is difficult. There was some idea that data brokerage firms and data intermediaries would work when it came to public data. So under the PSI directive, when that came in 2003 and 2008, the more development, it didn't really happen. I mean, there are some smaller companies that have provided public data on a commercial business, under a commercial business model, but they haven't really scaled up, as Inge said. And they might have some kind of advantage if they step into this business, but it seems like the Data Governance Act is also, it puts a lot of limits to these companies. So I am not too confident that they will actually grow that much.
Thank you, Björn. Martina, does this business model have an economic underpinning, rational?
Well, I don't see it at the moment. I agree with you all, because I think transaction costs are very high still for data intermediaries now under the Data Act, because they had first to approach all the consumers who have a special IoT device. So I need, as a data intermediary, I need to know who has bought a special IoT device with special data, which might be of interest for me. Yeah? And then I have to approach the manufacturer to conclude a contract with the manufacturer. And the manufacturer then might say, oh, there are trade secrets involved. And after I had first have to convince the consumer to give me the data and make a contract with the consumer. So I think the transaction costs are very, very high. I, as an intermediary, would go directly to the manufacturers because they know what data they have. They have the aggregate data. They are not out there. Then I don't have to collect them. I'm not so sure, I must admit, from a legal point of view, whether the the IoT manufacturers can give the data to data intermediaries. So perhaps they can contract that away from the consumers, I guess. So I think this would be cheaper then, at least, but I don't see a business model so far in the Data Governance Act. Thank you.
Thank you very much, Martina. Inge, and let us move then to the question how, if then how, namely, there is some kind of incarnation of friend clause. It's not for free, and friend envisages many complex challenges, how to define it. And we see some interesting examples in other jurisdictions where they move somehow to arbitration models. And maybe we can identify some good and bad examples or practices for us to apply it in this context.
Yeah, on the friend clause, I would actually have been in favor of letting a data transfer for free. I don't believe in this friend clause. I don't think data holders need a fee for this, because what I see in the market is that there is enough incentives to collect data. So I don't think there was a need to be concerned that we would not see these IoT devices anymore, or the collection of data anymore, had manufacturers or data holders been obliged to transfer data for free. And I think the friend fee, as we know from other fields, it creates a lot of questions on indeed what is fair, what is non-discriminatory. So I can imagine that this, in the discussions between the players, this can lead to a lot of delay in making data access possible. And indeed, there is examples from arbitration on how this could work. And the Data Act also creates a dispute settlement system, where the idea is that you can create a solution very quickly. So I think within 90 days. But there is still also an option for the parties to go to the courts. And if I'm correct, in the final version of the Data Act, there is no obligation for the parties to agree that the outcome of dispute settlement would have to be legally binding. So even if you go through this process, you might still end up at the courts to get a final legally binding outcome. So I think that this friend fee is another example, where we have to see in practice how quick solutions are achieved, and hopefully this is not used as a mechanism or ends up as a mechanism that creates a lot of delay and that actually undermines the whole objective of the Data Act in making data flow more easily across the internal market. So on the French fee, I'm quite skeptical, I must say. But happy to hear from the others how they see this.
So let us hear from the others.
Optimistic.
Thanks, Inge. Björn?
No, I agree with Inge. I don't see. I think it's very unfortunate that we have a FRAND clause here that it should be applicable. It creates a lot of transaction costs, which Martina can talk about. But I also see it's room for a lot of litigation. It's in that area, we know it all is in telecom. It's probably the most litigated issue ever, I would say. And I think, so I can only agree with Inge. I think it's unfortunate that we have this FRAND clause. We should have done it for free. It's more, so would be a better solution.
Thanks, Björn. Martina, is there any other alternative to this? Maybe you could somehow put it in the price of the device itself, ex ante?
Well, the most, as I already said at the beginning, from an economic point of view, digital data are public goods, so they could be easily be replicated. Yeah, and so I think it would be no problem to give both the manufacturers and the users a copy of their data generated, and then the users had the data and they could do with them whatever they like and give it to third parties for free or monetize them whatever they like. And perhaps also the manufacturers could do this. And so we didn't, in this case, we hadn't any additional transaction costs and bureaucratic regulations and negotiations and all these things. So this is all a waste of resources, I would say. But it, well, I think it creates some barriers so that still the manufacturers can exclusively use their data.
And when monitoring this discussion, Martin, as a follow-up question, did you notice the actions or some narratives which can explain why we have opted for this rather laborious model rather than going to directly the one which you have suggested?
No, I'm sorry, no, I don't, nothing about this. Perhaps Inge or Björn know more about this, but.
Okay, so let us move then to this more kind of broader jigsaw puzzle situation. We see unprecedented activity by co-legislators in the European Union adopting quite a few quite ambitious pieces of regulation and aiming to recalibrate the very structure and the functioning of digital markets in the broadest sense of the term. Do you think, Inge, you participated directly in the discussion, DMA and beyond as well, DSA and other pieces? Do you think they fit together well? Is there a kind of overarching rationale underpinning them, or they are just they just are expressions or the embodiment of the intentions to make the world a better place?
Yeah, that's a very broad objective. Maybe that's indeed what the EU is trying to do, but I sometimes indeed also struggle, seeing how all of these pieces fit together. I think the acts in themselves all have like a dedicated objective, but the question still is how they all fit together, because there is definitely overlaps, sometimes maybe even tensions, synergies, but there is many provisions that somehow relate to each other, and where the acts, if you look at it from a very legal perspective, are not always that clear about which one prevails, for instance, in cases of conflict. And I think for the Data Act, the two main ones, to me at least, are the GDPR for personal data, because you can imagine that many data sets that are exchanged under the Data Act also to some extent involve personal data. And here the Data Act says that it is without prejudice to the GDPR, but what does that mean? So you can argue maybe that means that the legislator already set a hierarchy and that the GDPR should always prevail. But does this then mean that if there is no, for instance, valid legal ground on under the GDPR to process personal data, that there should be no transfer of data. I think that is, yeah, not a satisfactory outcome, because then the whole purpose of the Data Act fails. So I would have welcomed, more specific guidance from the legislator on how you make these trade-offs. There might be cases where you can anonymize the data, but sometimes also the value of that data, then, that data is not so valuable anymore, cannot be used in a certain context anymore. And this especially plays a role in data sets where it's not me involved as the one who wants to share the data, but for instance, people that relate to me or people whose data is included in a data set that I then want to transfer to another provider. So these are the cases that will create the most questions. Another interaction that has already been discussed, especially by Björn, is with trade secrets. And there, I think if you compare it with the DMA and the DSA, I would say the Data Act is actually the most clear in how that interaction works. So the Data Act does say that we should not give up trade secrets, but it also creates a bit of insights on how you can still move data to another provider, even if it's protected by trade secrets. So for instance, by commercial confidentiality agreements or maybe technical restrictions that can be put in place. So there I would say the Data Act is more specific than, for instance, the DSA, which also has a lot of data access provisions, but they don't speak at all on how this interaction with trade secrets or other intellectual property rights would work. So to me, still a very piecemeal framework, where all the different acts have their own objective, but it creates a very complicated puzzle where we'll just have to see in practice how overlapping provisions can be interpreted in a way in the hope that all of these acts in the end still will be able to reach that objective. And I think the same applies to the Data Act.
Thanks a lot, Inge. Björn?
Yeah, I think it's sometimes a little bit interesting to see the historical development. So the Commission started out with the DMA and the DSA, and they're quite silent when it comes to interface between these acts and intellectual property law in many ways. And then slowly progress and they start to realize it. Then they put in some effort in the Data Act and talking about trade secrets and sui generis database protection and so on. While in the new proposals, for example, the one regarding health data, they actually take out all intellectual property rights. They say intellectual property rights are not available when we talk about health data. And that is, I mean, that's a huge surprise. I mean, it's because it does deal with a lot of intellectual property rights in the pharmaceutical industry, and we see if that would hold up. They also in that new regulation, the health data regulation, also talk about anonymized and pseudo-anonymized data, so that the GDPR should not be applicable. So and if we look at this historical development, it seems that we go to broader access right and transfer rights to data. At least that seems to be trajectory from the Commission. But I agree with Inge that they are very overlapping, and we have very specific regulation which works like lex specialis, I think, and there's some that works more like lex generalis, like for example the Data Act. And the GDPR is, of course, a lex generalis, I would say, compared to the other ones.
That was actually Marco Botta's point as well in his quoted paper recently when comparing DMA obligations and GDPR. And this plays an important role.
Yes, I agree. No, that could. I think that's an interesting point. If I would view DMA as lex specialis compared to GDPR, that would imply that DMA then trump GDPR. I'm not sure that was the idea when they wrote the DMA. I think they still had the idea that, as Inge said, that GDPR would be considered to be, would rule out the use of DMA and access rules and so on. But we see some. There's. I'm just going to say last thing. There's a very specific rule, regulation, which deals with independent service providers when you come to repairing trucks and cars and so on, under competition law, I think. And then there is a case where they say that that is lex specialis, and that should trump GDPR. And there were an ability for, it was Scania, the Swedish truck providers, that needed to provide data to an independent repair shop, even though that they claim that that would violate GDPR. So there are cases on it now. Quite interesting.
Very interesting. Thanks, Björn. Martina, how do you see this coexistence and co-interaction or interaction between different legislation, pieces of legislation of the latest wave and earlier waves as well, maybe?
Well, of course, I'm not a lawyer, so I can only talk here from a, well, evolutionary innovation economics point of view. And I think it's a very interesting situation we are now in. There's co-evolution between law and technology, and of course digital technology is way ahead but now well, in a piecemeal fashion, and nothing else is possible. The legislation starts, and I think it's well, we've seen some decades what's happening here, what's going on, whether this is the right starting point, setting up a trajectory, as Björn called it, yes, where broader access rights would then prevail. That is what economists would suggest, yes, but we don't know whether the legislation indeed will lead to this result. But I think it's not, the only thing one can do is to start with some legislation and then see what's happening, because also we don't know how the technology will evolve over time. So that's the best we can do now. And comment on it and make progress. But
thank you, Martina. Inge, maybe you can, I know that we don't have much time, but at least the main elements of enforcement mechanism.
The point about enforcement is quite interesting, because it's a piece of legislation that has a mix of an EU and national framework in a sense. So most of the enforcement, or all of the enforcement, happens at the national level by national authorities, where the member states have to choose which national authority they make competent. And the interesting thing here is that they can also choose to assign the competence to more than one authority. So what the text of the Data Act says is that for the personal data involved, the National Data Protection Authority has to be competent. But next to that, member states can also assign another authority for the other parts of the Data Act that do not involve processing of personal data. If that is the case, so if there is more than one authority at the national level, the member state also has to assign one as the coordinator. So for instance, in the Netherlands, the government decided to make the competition authority, so the authority for consumers and markets, the coordinator, whereas the Dutch Data Protection Authority will thus be competent for the personal data aspect. So they will have to collaborate and coordinate together. And then at the EU level, there's also a European Data Innovation Board, which brings together all these national authorities. So this mimics a bit what we already see also in data protection law or in consumer protection law, and also even in competition law. For instance, with the European Competition Network, that there is like a broader board that brings together all the different authorities involved. And then maybe one final aspect to keep in mind is that there will also be many cross-border cases. And there, of course, the question is whose authority is competent if this all happens at the national level. So there they chose for a similar approach as the one we have in data protection law, where it's the main establishment that is competent. And this I find, maybe a remarkable, even a problematic choice, because we see in the GDPR that this creates quite a bottleneck, because there are some member states that then have to do a lot of enforcement because they attract a lot of companies. So this, yeah, I wonder how this will work in practice. Hopefully we don't see a similar bottleneck as we see in GDPR enforcement, where the Irish and the Luxembourg authorities have a lot to do, and where the other member states who could do more, but they simply don't have the competence to do that. So yeah, it draws a bit from several different approaches that we see in other different fields, which is, I think, interesting to see. And hopefully it works well in practice.
Thanks, Inge. Björn?
Yeah, I think it's a very good point there with the bottlenecks and the development with the GDPR. The only thing I can add is I mean, I hope at least that there are rules for private enforcement when it comes to data access rights, and that not only for damages, that you actually have a right, and now we're talking about direct effect and so on, that you can go to court and obtain your data that you have a right to according to the Data Act or the DMA, for example. And I do believe that they have direct effect and are directly applicable under EU law. So that's.
Thank you, Björn.
Yeah.
Martina?
Well, I think since so far we do not know much about how this new Data Act will be applied and what the real problems there are, then perhaps it's a good thing that there are different national boards involved in adjudicating this or applying it, and then having something like this new innovation board Inge mentioned would be a good thing then to get a consensus on how to proceed from that. So that I think it's good that there's not only one agency or one board which adjudicates this enforcement at the moment.
Thank you very much, Martina. I mentioned at the very beginning the obvious, that you have authored impactful pieces, articles, and monographs in this area. So I maybe very quickly wanted to, based on some of your contributions, ask you individual questions. Again, starting with you, Inge. You mentioned in one of your co-authored pieces that in the era of big data and data analytics, the collective impact of data processing is becoming increasingly pronounced. This brings the limits of the focus on individuals even more to the fore. It's quite a statement, yeah. It traces the trend which we all sense in one way or another, but it also somehow epitomizes a significant refocus of our individual, the attempts to put the individual in the center of all regulations. It looks that in the cacophonic world, it doesn't appear to be the only solution, so to say. So we have to do different narratives simultaneously. Can you please decode, am I interpreted correctly this?
Yeah, so what we try to do with this co-author piece is make something transparent that we think is already happening, that we make trade-offs all the time between giving individuals full control over what happens in this case with their personal data versus promoting the collective interest. So one example to make it clear is if you share personal data, then this does not only affect me as the one that is sharing it, but it also affects others to whom my personal data relates. And also it can affect competition as a whole. So what we try to state by mentioning that the collective interest goes beyond the sum of each individual involved is that there can be this snowball effect with sharing personal data. So data has externalities, as economists would call it. So there is things that you cannot control as an individual by managing your data. What we see in the Data Act is that for the first time, a collective interest, one could argue, is given precedence over giving individuals full control. And this relates to this exclusion of gatekeepers as beneficiaries of data access. So even if you wanted to transfer your data to a gatekeeper under the Data Act, the legislator has decided that this is no longer possible because of this higher public goal or collective interest into promoting competition and innovation. But the point that we're trying to make in this article as well is that these trade-offs have to be made visible. So we cannot really see from the recitals or the discussions in the Data Act that this was really a trade-off that was made, also keeping in mind that this limits the control that individuals have. So you see this happening in many other areas where in the EU, I sometimes think we want to have it all. So we want to have individuals controlling as much as possible, but we also want to have innovation, want to have competition, but you can't have it all at the same time. So you have to think of making choices where sometimes indeed the individual's rights get precedent, but sometimes maybe in other situations, it's the collective interest that prevails. And then indeed, very controversially, that means that individuals cannot always fully control anymore what happens with their personal data. And another example, and then I will close off, is where you see this is in the health data space. So where you can imagine that sharing health data can tell us a lot about diagnosing or treating certain diseases. So should then every patient have the right to decide whether that data that is very valuable for society is included for research or not? So this is an example where you see possible tensions between the individual interest and the collective interest, where I think democratically elected bodies should be the ones making such choices. And I think that, we need to discuss that more to make sure that these choices are made in the right manner. So that's what we try to put forward with that article. And I think it's a very, important trend that we indeed, as you were already saying, see in more and more areas.
Absolutely. Thanks a lot, Inge. Björn, you deal with juristically refined specific novellas in this field, and it's very intriguing. But my question about your recent research somehow echoes the one addressed by Inge, and you say that the energy and speed with which EU institutions are developing these diverse and sometimes dysfunctional sector-specific regulations for the digital economy certainly call for a more holistic approach. So we see the transition from exclusively individual approach to more kind of societal. Here we see from more focused, targeted approach to more holistic as well. Can you elaborate on this aspect, please?
Yeah, it boils down to the research I did during the pandemic. To me, it was one fortunate aspect about the pandemic. I actually had some time to do some research without having to travel to all conferences and so on. And then my take on the whole new tsunami of new regulations coming out of Brussels was that it's really a new market law, as we say it, so regulation of markets, of the free economy, but for the digital space. And many of these rules, and I think the Data Act is a clear example of that, where they try to regulate it by providing rules for how contracts should be written. It's like private law. From a competition law perspective, we would say it's behavioral regulations, like how you can behave in your interaction with other business to business, or business to consumers. While I think if we start to realize that this is regulation about Industrial Revolution 4.0, this is we have a whole new legal system here for something we haven't seen before. Then we need to start from basics, and I think one of them would be to try to understand what is the property rights for the digital economy, and they are not exclusive. So I agree with Inge that we cannot have exclusive rights where individuals can prevent others from accessing their data, but we could still hold on, because I do think there are many good aspects to property. One is that you have the right to access, for example, you have the right to transfer. And that is two rights within the bundle of rights that we call property. And maybe we should try to regulate that in all fairness perspective and with the idea of creating innovation and so on. And perhaps then we do not need all these behavioral rules that we're saying now being created, both in the DMA and in the Data Act. We could leave that to the market to come up with it themselves. So that's why if I want to do some commercials, that's why I wrote this book about it. But you don't have to buy it. You send me an email and you get a copy.
Cambridge University Press, I believe.
Yes, it's Cambridge University Press. Yes, true.
Congratulations, Björn. Thank you very
you.
much for this. Martina, and this echoes very well your latest or recent research co-authored with Wolfgang Kerber, which also pleads for the property rights or perceives this issue from the perspective of property rights theory. Can you please elucidate the key messages?
Yeah, so, well, it complements both the research of Inge and Björn, I guess, in this respect. We applied the property rights theory, which is a rather old theory in economics also, yes, with this bundle of rights approach, to the Data Act. And we found that so far this hadn't been done, that this property rights theory was applied to data issues, and so it allows one to very carefully analyze the different incentives and market players, etc. And again, as we already talked about, from an economic point of view, there are not that many market players which would call for exclusionary, strict private property rights to digital data, and so also, and in particular in regard to innovation. So it's not clear that giving either manufacturers or users exclusionary rights would open up more data for innovation. So there should be broader access rights. And from an innovation point of view, it's not the single individual data point which is of interest for innovators, usually. It's the aggregate data set. So it's not the individual data from using an IoT device, which are of economic relevance and value, yes, but the aggregate data set, and mainly not homogeneous, but heterogeneous and diverse data sets, which I guess are more valuable for innovators. This also calls for opening up the data, broadening the access. So, and in this way, I think we come to a similar conclusion like Björn and Inge from this property rights perspective.
Many thanks, Martina. So I'm very grateful to you all for this really illuminating, and detailed and insightful conversation. But before we finish, we have this tradition. We close with asking your recommendations, maybe some tips to do's and don'ts. We remember this tradition for students, for those who will bring new blood, new energy, new ideas to this discipline, and who will be probably dealing with the 2.0 iteration of these ambitious pieces of legislation. Where should they focus their attention? What should avoid these kind of issues, Inge?
If you like me to go first, so I think what a trend that I see that is where also a lot of demand from the market is. So if I were a student now, I would make sure that I would devote attention to interdisciplinarity, because the way I see it, like the challenges that we have in society, like data and digitization is one of them, but another big one is also, for instance, climate change. So, and I see there that it's not just enough anymore to know the law, for instance, but you also need to know the disciplines that are closely related to that. So I would really devote attention to understanding also other disciplines next to the law, for instance, if you are a law student, on a theme that you're really passionate about. Because I see that, there will be a lot of demand for people who can think outside of the box. So that's one piece of advice that, I think would be, I would keep in mind if I were studying now. And
Many thanks, Björn.
Yeah, I agree. I think that the future research it's more focused on problems and then can address those huge problems from different aspects as a lawyer or an economist or a technology data researcher or something like that. One topic I think which is not in the horizon, so to say, which is closer to is this what is the cybersecurity or security? You see this both in the Data Act and we don't know what security means. Is it public security or is it? Yeah. So I think that's security. I would focus on security. Thank you.
Thank you. Martina?
Yeah, I also agree with Inge that interdisciplinary efforts are very relevant. And speaking to economics students, I hope they would take the effort to delve into the institutional details of different legal, regulations and systems, because for economists, we all build our models and test them empirically. It's a whole other effort to do there. And I think it's very important also for economics to be a meaningful or remain a meaningful science to delve into these institutional details. So thank you.
Thank you very much. Inge Graef, Björn Lundqvist, Martina Eckardt, I'm very grateful for the opportunity to learn from you today at this conversation, and I hope we have managed to create some interesting discussions over the last 70 minutes. Thank you very much indeed.